By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. A very good Um, and hello, everybody. Welcome, all you lovely people. Welcome back to another exciting episode of Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm going to be with you for an hour or more. And I'm absolutely thrilled that you have joined us today, wherever you have joined us from, whether on Facebook, LinkedIn, Twitter, which is X now, Instagram, even YouTube for sure. So, thank you, and folks out there. Today is just not any ordinary day. It is a day filled with valuable insights, expert advice, of course, and a lot of fun as well. So I hope you're absolutely ready because we are going to have uh, a very important guest, I would say. And let me introduce you for the first time. And she is none other than Gianna Mary Florento, our guest for today's masterclass, joining us for the first time. And she is also co-founder and partner of For and Florentino. So thank you so much, Gianna, for joining us.
Good morning, Nipa. I would like to first thank you, as well as everyone, the team at Immigration Jobs Talk Show, for having me this morning. I'm very excited to be here.
Me too, me too. So I'm sure folks out there who have joined us, and you too, since you've joined us for the first time here, we would love to get to know you a little better. So, Gianna, tell us a little more about yourself and even about For and Florentino.
Right. So my name is Gianna Marie Florentino, and I am the co-founder and managing partner at Forum Florentino. We are a full-service immigration law practice. We practice immigration law regarding family-based applications, employment-based applications, humanitarian benefits such as asylum, U visas, violence against women petitions, as well as uh, T visas for victims of human trafficking. I was born and raised in the New York area, and we are a completely virtual firm as well, which means that we can practice from anywhere, which is really great for our clients, as we're fully available to work remotely with them, and they never have to come into an office to get in touch with us or to have us work on their cases.
Get in touch with her. Her details are already displayed on the screen. And definitely, Gianna has dedicated her career to helping immigrant families. So, friends, today as well, she's going to be sharing her wisdom with all of us. So, I'd say grab your pens, your paper, folks, because we're going to dive deep into the world of U.S. asylum seeking. And I hope you're ready for this. So, I hope you are ready as well, Gianna.
Yes.
So, first off, what is seeking asylum? What does it mean?
Right. So, seeking asylum, asylum is a legal process, a legal protection offered by the United States government for those people who are escaping persecution and are attempting to seek refuge in the United States. Asylum, the legal requirements are set forth in the Immigration and Nationality Act, Section 208. You can find the exact legal requirements for asylum, which we will be going over in great detail. I think one of the most important things to keep in mind when thinking about asylum is that it's a little bit different from refugee status, in that asylum seekers are actually in the United States, on United States soil, or they're at a border or a port of entry, whether that be land, sea, or air. Whereas refugees are typically applying for registration through the UNCHR, which are for applicants that are located outside of the United States. So when we're talking about asylum, we're talking about people who are here at the border or who are already here within the United States.
Okay, thank you so much, Gianna, for that. And well, so that is it, friends. And thank you so much for joining this masterclass today with Gianna. It's going to be a great one. And today's topic, as you can already see on the screen, are you a U.S. asylum seeker? So, yes, this is a masterclass, how to obtain an approval. Gianna, maybe you could tell the folks out there who have joined us what can they expect from this episode today? What are they going to get?
So today we're going to go over an in-depth analysis of the application process for asylum seekers. whether that process be defensive, meaning that the asylum seeker is already in removal proceedings and is applying for asylum as a defensive mechanism to deportation, or whether we're talking about affirmative applications for applicants who are not in deportation proceedings, but nevertheless wish to apply for asylum. Additionally, we'll be talking about how this process differs for recent entrants as opposed to people who have had their asylum cases pending for several years. We'll also be discussing how the treatment of minors in the asylum process is a little different than the treatment of adults. We will also be kind of going over the evidence requirements for cases of asylum and what kind of evidence you need to prove your claim, as well as the legal complexities regarding asylum and approvals for asylum here in the United States.
Okay, and friends out there, thank you. Already I can see so many friends commenting. So hi to NoFold33 on YouTube, Venu, Nehas Shetty, Shirin, Pavan, and well, thank you. And I seriously, we can hear you. So I think we should just take up this first one quickly, which is from Shirin. And Shirin is asking, can asylum seekers work in the United States while their application is pending?
Yes, so this is a great question and a very important question, as many asylum seekers are eager to start working once they do arrive here in the United States. So something that's important to keep in mind is that you need to have 180 days pending in order to receive an approval on a work permit application. So what this means is once you file your asylum application, there will be the passage of time, which is calculated using the ASQ clock. So this clock basically counts how many days you've had your asylum application pending, whether this be pending with the court or pending with USCIS. This is essential to receiving an approval on your work permit. The idea behind these work permits, I believe, is that the government is kind of giving you a benefit as your case is taking a long time. And in the government's eyes, anything longer than 6 months warrants a work permit. So the short answer is yes, you can. But you do have to wait 6 months following the initial filing of your asylum application to actually apply for that work permit. That work permit will be what's called a C8. So it's a category C8, and that is for pending asylum applications, and that allows you to work legally here in the United States upon approval of your work permit. Additionally, back in September of 2023, the USCIS actually extended these work permits for a validity period of what was formerly 2 years up to a validity period of 5 years. So now all C8 EADs or employment authorization documents, once they are approved, will be valid for 5 years. And if you fill out on the form that you would also like a social security card, you will also get a social security card with that as well. So this is a huge benefit to asylum seekers who have had their applications pending for longer than 6 months.
Thank you for taking that up. And Shirin, thank you so much for asking that very important question. Yes, and let's dive into this topic deeper, Gianna. I even prepared some questions myself. So, talking about it, what is the initial step with applying for asylum in United States, and how does an applicant, officially start the asylum application process?
Right. And so this is a very great question. The initial answer is that not every asylum applicant is going to have the same first step because what shapes your asylum process really comes down to your manner of entry, the timing of when you entered, who you entered with, and this will kind of determine whether or not you're going to have a defensive application or an affirmative application. So I can start off with defensive, as I think this is what most people think of when they think of asylum. You think of the southern U.S.-Mexican border. A person, an immigrant, kind of presents themselves at a port of entry, whether that be a land border or a sea border or an airport. But here we're going to talk about at the actual border, right? So typically, an asylum seeker will present themselves at a port of entry. Most often, they do not have a document to already enter the country, but sometimes they are what's called paroled, which means that in the Customs and Border Patrol protection officer's discretion, he can or she can choose to parole the asylum seeker into the United States, giving them a kind of lawful entry. Sometimes this comes with a work permit. Sometimes this comes with a lawful period of stay of a year or 2 years. So this can kind of affect the way that your asylum application begins. Because, for example, if I am an asylum seeker and I present myself at a port of entry and I'm not paroled into the country, then I'm usually given, whether it's right at the border or if I'm detained during my detention, I'll receive a document what's called a notice to appear. And the notice to appear will state charges against the immigrant, basically stating you are not a resident or citizen of the United States. You are a resident of or citizen of, for example, Mexico. You were not lawfully admitted or paroled into the country. And it will also state charges. So, for example, if you basically enter the border not at a port of entry, like what we like to think of as maybe a gap in the border wall, that would be what's called an A6 charge. And so this A6-1 charge basically states that you attempted to enter the United States without presenting any documents and without inspection by an immigration officer. However, if you choose to go straight to the port of entry and say, hi, I'm here, I don't have any documents, but I would like to apply for asylum, then you'll get usually what's called an A7 charge. And this charge just states that you presented yourself at a port of entry for inspection, but you did not have any lawful documents to enter. So once you get this kind of magical piece of paper, which is the NTA or the notice to appear, that means that you are going to likely be placed into immigration proceedings. And once this NTA is served on the applicable immigration court, the deportation proceedings essentially begin. Once the proceedings begin, you have exactly 1 year from your date of entry to apply for asylum. So it's a very strict 1 year deadline. There are some exceptions to this deadline, but they are very difficult to meet. So strangely enough, I would say the initial step for applying for asylum is getting to the United States and actually submitting the application within the 1 year deadline. And you might think there are some more preliminary steps, and in some more complicated cases there are. But generally, whether you're doing it defensively or affirmatively, the first step is to actually send that application. And so also too, this includes sending it for biometrics. So if you're doing it defensively, there's 2 different ways that you can do it. There's 2 different requirements that you have to meet. You have to send it to the court so that the court receives it within the 1 year deadline. But you also need to send the first 3 pages to the Nebraska Service Center at USCIS in order to generate a request for biometrics, which are essentially your fingerprints, where the government is able to run a background check on your criminal history and any sort of kind of a flag that might come up in your case.
Okay. I mean, Gianna, you have touched some very important points today already in just the first few minutes. So these points, do they apply for applicants only from the southern border or anyone from any country?
It applies to anyone from any country. So, for example, I can give you a different kind of example. So, say I come from Jamaica and I get a B1, B2 tourist visa to enter the United States. Say I fly into New York, I fly to JFK Airport, and I get there and I enter, and now I'm in the United States. It might be the case that I entered on a tourist visa, and that during my time here, I decided that I cannot return to Jamaica due to all the persecution I've been facing there, and that I now want to apply for asylum. In this case, it's a little bit different because when you enter the country lawfully, you're not going to receive that notice to appear because you're not charged with being removable from the United States or inadmissible to the United States. You're not charged with anything because you've entered lawfully. Right. So, for example, maybe I'm in month 4 of my stay in the United States and I decide I want to apply for asylum. So I would send that asylum application not to the court because the court has not received any sort of notification regarding my case. It's not been served with a notice to appear. So I'm not in deportation proceedings. So what I would do instead is I would send that application directly to USCIS, United States Citizenship and Immigration Services, and they would receive my application and issue a receipt notice. And then I would kind of continue the process with them from there. And in this way, there are a lot of differences between the affirmative and the defensive process. But in this way, you'd be able to complete it without having to appear for any sort of court, although you might eventually have an asylum interview.
Okay, very interesting. And since you're already talking about it, how do affirmative and defensive asylum applications differ in the US? And what are the circumstances that lead an applicant to choose between affirmative and defensive asylum?
Right. And so I really liked this question when I read it because I thought it was kind of funny and interesting because unfortunately for defensive applications for defensive applicants they don't get to choose the kind of criteria that determines whether or not you're going to have an affirmative application or a defensive application is whether you've been put in immigrant in deportation or removal proceedings. So that's going to be the main factor. So that really bears on your manner of entry, whether you entered with legal status, whether you know who you're traveling with can sometimes determine that as well. So the real difference between affirmative and defensive is that with affirmative you get two chances to win your asylum case, and that's why if you can ever apply affirmatively, we always recommend that you do that. The reason is if you apply with the United States Citizenship and Immigration Services for your asylum application, and say you have your asylum interview, you submitted evidence, you've provided maybe witness declarations, and we'll get more into that later probably, but you conducted your whole case and they said, I'm sorry, we are denying your application. We find you not to have established your eligibility for asylum. What happens at that point is if you are denied with USCIS, you will get referred to immigration court. And immigration court, you will have the ability to present this application again in front of an immigration judge. So if you apply affirmatively, you get the option to try your case twice, essentially. But if you unfortunately are placed in immigration proceedings before you get the chance to apply affirmatively, that is your one and only shot at asylum, barring any appeals that you might file.
Okay, but could we have more clarity? I mean, just the difference, the versus affirmative and defensive asylum, maybe a little bit.
Right. So it really the difference is who's adjudicating your case, right? So in the court, you have a judge. You're going to have a government attorney who you are arguing against in kind of an adversarial process. You know, me in my defensive capacity, I'm going to represent my client and
Mhm.
attempt to, you know, establish eligibility for asylum, submit evidence, make arguments in front of a judge who will ultimately determine what the answer, whether the application is going to be approved or denied. Whereas in an affirmative application, most of the legwork in this application is done written. It's written work. So you're going to submit everything, you know, in usually one package, or if you want to submit other evidence later, you can submit a second package. But essentially, you're kind of proving more of your case in the written package that you send to United States Citizenship and Immigration Services. However, you will have likely have what's called an asylum interview. But the asylum interview functions a lot differently than a final hearing in immigration court. So with the
Mhm.
asylum interview, you know, you'll go with your client, and essentially the adjudicator will ask questions. And I think this is something that we'll cover a little bit later as well. But the adjudicator will ask questions of the applicant, and the attorney's role in the asylum interview process is very limited. So the role is to sit, take notes, and if the adjudicator asks you a legal question or a question about the procedural history of the case, you're allowed to respond. But it's not like an immigration court where you're actually presenting direct examination, cross examination, opening arguments, closing arguments. You get a lot more ability to kind of demonstrate your case in the defensive
Mhm.
process, and that's because it is like you do have substantive due process in you know during the court hearing, whereas the asylum interview is conducted by not a judge, sometimes not even an attorney, just a government worker who is an official of USCIS who's kind of looking at all of the application materials and making a determination based on that.
Right. And every case is so different and so individualistic. So I'm only sure.
Right.
Let's take up one from the chats, all right? This one is on YouTube from Venu. Do the NIW applicants need to pay asylum fee to USCIS for their I-140 self-petitions from April 1st, 2024? Or will this fee be needed for only perm-based I-140 applications? Do
Okay,
you
so
want to
this is
take
a
this up? It's out of the
yes.
topic.
So this is a bit of a complicated question, but I think it has a sort of simple answer. There are no fees to apply for asylum. So the short answer is no, because there are no fees. It is a free application, and for that reason, you will not have to be responsible for any fees.
Great. We know that's good news for you, I hope.
Yeah.
All right. Let's move on. Well, Gianna, how can one navigate the U.S. asylum application process, and what are the step-by-step details involved, if you can specify, in the U.S. asylum application process only?
Right. So again, this will depend whether it's defensive or affirmative. But for defensive applications, like I said, you get that notice to appear. You file that I-589, and which is the form for asylum, and you want to make sure that you do that within the 1 year deadline. Applications that are filed after the 1 year deadline, which is 1 year from your date of entry, are going to face a lot of challenges, as you need to argue that you might qualify to fit one of those exceptions. Apart from filing the I-589 on time, you want to submit an ample amount of evidence to support your claim. Additionally, if you are in immigration court, what's going to happen is they won't immediately schedule you for a final hearing. Most judges will schedule you for what's called a master calendar hearing. And a master calendar hearing is a way to organize the different types of cases, the different types of claims, and for the judge to kind of control their docket and decide, when they want to make certain evidence due. They call those call updates, when the call update will be for certain evidence and such like that. So if you are in the defensive process, typically the first thing that will happen is you'll get your first court hearing, which is a master calendar that will get scheduled, and you can actually look at that on a website that's called ACI, Automated Case Information, because sometimes you get the notice to appear that tells you when your first court is, but sometimes later the court changes the date, and there's no way apart from looking it up online for respondents to know unless they are mailed a new copy. Which they're supposed to be mailed a new copy, but sometimes things get lost in the shuffle, and so it's always good to check when that first court date is, because if you are to miss any of your court dates in immigration court, you might actually receive an order of removal from the United States for just missing one court hearing. To navigate the process, I would make sure you're checking on your case online. You maybe consult with an immigration attorney to kind of evaluate the strength of your asylum case and manage expectations regarding to what is possible, because unfortunately, nationally, only 30% of people do win asylum. And so it is important to know kind of the strengths and the weaknesses of your case and the possibilities going forward.
I mean, do you have any cases you want to share, which is similar to what you just said just now?
Right. Yeah. So, I mean, I have a lot of cases pending in immigration court right now. Typically, like I said, I'll have potential clients or clients reach out to me and say, well, a lot of my clients are Spanish speaking, so they'll say abogada, which means attorney in Spanish, and they'll say, I have a court hearing on this day. What do I do? Are you going to come with me? What's going to happen? And I usually tell them, don't worry, this is just the first court hearing, right? So this is an opportunity for us to discuss with the judge, what we're applying for. And usually that's asylum, what kind of evidence to expect going forward in this case, and what kind of your claim is about. Another really important thing to underscore about navigating your asylum case is regarding what's called prosecutorial discretion.
Mhm.
And what that means is that sometimes the government attorney from the Department of Homeland Security will, in its discretion, agree to dismiss a case. What this means is that if you do not have a very strong asylum claim, and you perhaps don't want to have to present that claim in immigration court, but you also do not want to receive an order of removal, you can sometimes make a request to the Department of Homeland Security to dismiss the case in its discretion. Some cases that are usually more favorable for prosecutorial discretion are cases of families when there are children, maybe if there's some sort of medical hardship for the parent or the child, um, and other things such as if the applicant, the principal applicant, or the child is eligible for another benefit. So, for example, a lot of children are eligible for what's called the Special Immigrant Juvenile Visa. And this is for, without getting too much into it, this is for children who are here with no parents, or sometimes with one parent or an aunt or an uncle, who are under 21 and, due to abandonment, abuse, or neglect, are eligible for this visa. So, for example, if there's a mother and a daughter in a case, and let's say the mother is engaged to a United States citizen, and the daughter is in the process of getting her special immigrant juvenile status, the court, as well as the government attorney, will consider that collateral relief as reasons to potentially dismiss the asylum case, to kind of, in the interest of, judicial economy, and kind of, resources and things like that. They'll agree to actually dismiss the case so that the person can, with their not strong asylum claim, doesn't get ordered removed. So it's
Okay, thank.
sorry.
Yes,
Um,
yes, please.
it's important then that you discuss with an attorney whether your case, what and get multiple opinions if needed, but what is the strength of
Yes.
your asylum claim, and what is the other eligibility for collateral relief? Because in this way, you might be able to even negotiate maybe a better deal with the immigration court.
Great. Thank you so much. I mean, that was very detailed, and I'm sure it's pretty clear, folks out there, whoever is watching us right now. We can take up one more question from viewers out there. Let's take up this one from Kabir. My fiance's asylum request was approved, and she received the travel document. Can she apply for a visit visa to India with the travel document without using her original country passport? I think she wants to ask.
Right. Okay. So this is a case where the asylum case was already approved, and since she must have applied for the asylee or refugee travel document. So can she visit India without using her original country passport? Well, in order to use and effectuate that travel document, you do need a valid passport. It typically does not matter where the passport is from, as long as you have a valid passport to travel outside of the United States. So in this case, I'm assuming she doesn't have a United States passport because she's not a citizen yet. She clearly has an Indian passport, unless she has some other third passport, like an EU passport or a Canadian passport, perhaps. She's not going to be able to avoid using the passport, as you do need to have that in order to travel. Without knowing more detail on the question, that would be my answer.
Thank you for taking that up. Well, if you want more clarity, Kabir, you can keep posting your comments for sure. And Gianna, we've already reached half the mark. And yes, the details for her contacts is available on the screen, friends. You can note them down. You can call her on the number 516-605-3354. And you can even email her gflorentino at 4florentino.com. That is where you can email her directly, and even visit her website, 4florentino.com. And definitely, folks, thank you so much. I mean, we are definitely diving deep into our masterclass today with Gianna Florentino, of course, and that is on how to obtain approval as a U.S. asylum seeker. And let me tell you, the insights from Gianna definitely have been like surely very, very enlightening so far. So I'm sure it's going to keep getting better. But yes, stay with us, I would say, keep those comments coming and let us know your thoughts also, your questions, your emojis. I mean, your reactions to this video. Definitely keep them coming. And if you're tuning in our lives after the live stream has ended, you can also keep commenting, because we will make sure that you have your questions answered from the attorney, and in this case from Gianna herself. So drop your questions in the comments below, and we'll make sure you get all the answers you need. And of course, keep those keyboards clacking, I would say. And Don't go anywhere because we are going to speak more about how to obtain an approval as a U.S. asylum seeker. It's a masterclass, so stay with us for more amazing content. So we'll just go for a short break, a breather. Stay with us, friends.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
So, again, to all you lovely people out there, thank you again for joining us, for staying with us after this break, of course, the short break we just had. And this is Nipasa Pradhan on Immigration and Jobs Talk Show. Today we have with us our guest, Gianna and Florentino, and she is here from New York City. Very, very pleased to have you, and I hope you're enjoying this discussion today. Basically, a masterclass on how to obtain your U.S. asylum. I hope you're enjoying.
Thank you very much, Nipa. Yes, I'm enjoying it very much. Thank you so much for having me.
Thank you. And friends as well, keep your comments coming. We are definitely going to take more questions. And No Fault says, I love you, G. That is so sweet. Well, we'll take up more questions for sure. But let's start with Pavan. Pavan from the audience. This is on YouTube. Is asylum seeker eligible to apply non-immigration work permits and also for green card after H1B?
This is an interesting question. So, are they eligible to apply for non-immigration work permits? So, I'm trying to think of what type of work permit the asker of this question might be thinking of. I mean, so as I explained earlier, the only work permit that asylum actually qualifies you for while it is pending is the CAEAD. If you independently qualify for another employment authorization document through another benefit, I'm not aware of any provision that prevents you from doing that. With respect for the green card after the H-1B, so if you're applying to adjust for your residency, I'm not sure if the question is based on adjustment after H-1B kind of eligibility or H-1B status or based on asylum. But either way, you actually, once you have your green card, you actually don't need a work permit, period, because the green card is your work permit. You don't need an individual work permit to work. So whether you get your residency, through H-1B status, some process through that way, or you get it based on the grant of your asylum claim, you are eligible to work in the United States based on your residency.
Okay, so I mean, sometime back you spoke Spanish. You speak Spanish? I mean, you originally Spanish as well?
No, so actually, I am Italian American, but through
Oh,
working in immigration, particularly in the New York City greater area and on Long Island, I've met many Hispanic clients, and so actually they've mainly been teaching me for the past year and a half. So now I do speak Spanish, and that's I have my
wow,
clients for that.
that is really nice. So you're very fluent, I'm sure, and it's
Creo que sí.
very helpful to your clients.
Ya, estoy practicando todos los días. So, no es perfecto, pero estoy mejorando.
I wish I could reply to you in Spanish as well, but I mean, you sound pretty fluent. I'm sure you are.
I'm
So
trying.
I'm sure Spanish folks out there also, if you have to ask your questions, you can even ask in Spanish if you're comfortable.
of
For
course.
sure. So you speak two languages, Gianna?
Yes.
English and Spanish.
Yep, that's it. No more, just those.
Okay, great. All right. So let's move back to our questions then. All right. Maybe you could tell us what are the critical elements that contribute, to a strong asylum application, and maybe how can an applicant even demonstrate credible fear or persecution effectively?
Right. So I like to think of elements of an asylum claim in terms of the three C's. So the first being credibility. So again, whether it's affirmative or defensive, whether it's a credible fear interview or your final hearing, the client's credibility is essential because the adjudicator in the case needs to believe that what the applicant is saying is the truth, and also that that merits that the fear that the applicant fears is also a credible fear, and that goes into the credible fear interview a little bit more. But that means things like speaking clearly, making eye contact, being responsive to the adjudicator's questions. It's really important that the adjudicator feel as though you are, not holding anything back with respect to your asylum claim. The second C would be corroboration. So it's one thing to testify really well about, what happened in your home country, what persecution you faced, when it happened, all sorts of things like that. But it's another thing to have corroboration, independent corroboration for your case. So corroboration can come in the form of evidence. I really typically like to submit at least one affidavit or declaration from a witness to the persecution, or whether that be a friend or a family member who was made aware of your situation through either physically witnessing the events or through talking to you in the days, months, or weeks following, to kind of give an independent account of what happened that is sworn before the court or before the adjudicator. Other forms of corroboration could be police reports. So if you did have a crime perpetrated upon you, getting a police report or at least filing a police report in your home country can sometimes be really critical to showing the adjudicator that this is an independent report that corroborates my asylum claim, and that you should believe me because I do have these reports. Or for example, if you were a victim of violence, maybe you might have a hospital record or a medical report. Maybe sometimes you won't, and that's okay. But if you do have the more independent sources of corroboration that you do have, I think the better. With respect to the last C, creativity. So I kind of think, with respect to the actual legal requirements for asylum, depending on the case, you do need to think creatively about your legal argument. And so if you want, we could go over kind of the what is asylum in regard to the legal requirements, because I don't think we've actually talked about that yet.
Sure, why not? Why not? A little sneak peek would be good.
Right. And so, before just kind of a preface, asylum is extremely complicated and there are a lot of legal requirements. So I'm just going to be setting forth kind of the main basis for asylum, but there are kind of other ancillary rules here. So basically, you need to demonstrate that you have suffered past persecution or that you have a well founded fear of future persecution based on one of the five protected grounds. So that would be race, religion, national origin, political opinion, or membership in a particular social group. So the persecution that you faced or that you will face must be based on one of these categories. And that is kind of the big limiter when it comes to asylum cases, because maybe, I suffered really terrible things in my home country, but if it's not because of my race, my religion, my national origin, my political opinion, or membership in a particular group, it unfortunately is not going to, you're not going to be able to establish a cognizable legal claim for asylum.
Okay, thank you for taking that up and for, clarifying even more details on it.
Right.
Thank you, Gianna. And
Of
I
course.
actually wanted to ask, can people who come legally to US on whether it is B1, B2 visit visa apply for asylum? And what are the chances of approval if they can apply? And what kind of documentation is required?
Right. So I think we did talk a little bit about this earlier in the instance of the person from Jamaica who came on a B1. You absolutely can apply for asylum. That would be an affirmative application, usually, as you typically won't receive a notice to appear before you apply within that 1 year deadline. In terms of evidence, so regarding whether it's in immigration court or it's with the U.S. CIS office, there's going to be a kind of a battery of evidence that I would recommend that you include. So number one
Mhm.
is going to be the actual form I-589. So that is the asylum form that you need to fill out, and kind of it's very very detailed. You mentioned all of your family members, where they all live, where they were all born, what kind of persecution you faced, if you fear torture or other forms of persecution. You can list all of that there on the form. And I think it's really important to be broad when you're filling out this application, because maybe you have multiple different grounds of persecution, and so it's good to kind of disclose all of them right at the beginning of your application. Um, Additionally, you're going to want to submit what's called a personal statement. So this is kind of like a self affidavit, explaining in your own words what happened to you in your home country and why you believe this qualifies you for asylum. It's really good to have this with your application to kind of fill the gaps on the application of what is missing, so that the adjudicator really understands the situation you're going through and what led you to apply for asylum. With regards to other evidence, like I said, any objective evidence, police reports, medical reports, death certificates of family members, if that was, part of your asylum claim. Additionally, something that's really important in asylum cases, which I think is maybe different from the employment area, is that you really want to submit country reports on, human rights practices, or kind of on the situation in the home country, what's going on over there, as well as news articles, to demonstrate to the court the context under which this persecution is happening. It's kind of difficult to explain what's happened to you, and why that's persecution if you can't link it to kind of a broader problem in the country. Because another requirement to asylum is that the persecution is either occurring at the hands of the government, or it's occurring at the hands of a third party that the government is unable or unwilling to stop from persecuting you, or they're unable or unwilling to protect you from the persecution. And so, for example, if my claim is based on, let's say, gang violence, these claims typically have a lot of legal challenges, but I'm going to want to show that, the persecution I received from this gang, they're trying to extort me or they're trying to harm me. I want to show that that is a practice that is widespread across the country, that the government is essentially acquiescing to in their refusal or inability to fix the problem. So that's where country reports become very important for asylum cases.
Okay, okay. And, is there a need to provide proofs for people of countries like Ukraine, maybe Syria, Afghanistan, or other countries where, there are serious problems, it's a national issue kind of.
Right. So you might think no, right? Because everyone knows what's going on. But I would recommend that you submit them anyway, because it's more proof for your case. Maybe you want to tailor the types of different articles that you're including, so that it can help you make your argument. However, you can ask the judge, if it is an immigration court, to take what's called judicial notice of the country conditions. So if you didn't submit any conditions, you can say, Your Honor, I would like to formally ask that the court take, judicial notice of the situation in Ukraine. And, they could say, so noted, or, we will take notice of this. And in that way, the court is able to kind of acknowledge that the court knows what's going on without having to actually submit formal evidence. But you don't have that same concept, I believe, with affirmative applications, as there is no, it's not a judge who can take judicial notice. So I would recommend always filing, kind of a thick packet of country conditions.
Great. Thank you for answering that. Thank you for taking them up.
No problem.
Well, I think let's just take one or two more from my side, and then we'll jump into all the chat questions, if that's all right. We
Okay.
have a lot of people asking many questions.
Okay.
So, Gianna, I mean, Are there any recent changes that have been made to asylum application process, and have these changes even impacted applicants' chances of being granted asylum?
Right. So yes. So there are a lot of recent changes in the asylum process, and asylum really is one of those areas that is constantly changing. And I'm sure many of our viewers are aware of that. You see in the news, it's a very political area of the law, of immigration law particularly. And every new president and every new administration that comes in has a new set of rules and a new set of additional requirements that they want to add on to the asylum process. So right now we actually are looking at Biden's new asylum processing rule, which is now in effect currently. And this rule is going to affect asylum seekers in many ways. So for one, it's important to note that this rule only applies from applicants who entered the country between May 11, 2023 and May 11, 2025. So applicants that are entering right now, this is applying to them. So this rule actually allows immigration authorities to deny applications for asylum to applicants arriving at the U.S. Mexican border who enter the country without authorization, without first applying or seeking protection in a third country that they've passed through. It also allows the Department of Homeland Security to argue that an applicant is presumptively ineligible for asylum based on a simple procedural requirement of not using what's called the CPB-1 app to help them schedule appointments at the border. So this rule can actually have great consequences, as it's going to allow the Department of Homeland Security to argue that large swaths of the asylum-seeking population is what's called presumptively ineligible in virtue for asylum, in virtue of the fact that they either did not apply for asylum in a third country that they passed through, or they did not use the CPB-1 app when applying at the border. However, there are some detailed exceptions to this rule, which I think are important to note. So these are the following exceptions are this. If you are, traveling to the border, the U.S. Mexican border, with a group, a group of people, usually family members, if you or one of the people you are traveling with, who is also your family member, has done one of the following things, then you are not subject to this rule. So if you were authorized to travel to the United States based on an approved parole process approved by the Department of Homeland Security, you are not subject to this rule. So that includes people coming in on the parole process CHNV, the Cuban, Haitians, Nicaraguans, and Venezuelan parole program. It applies to other parole programs as well. So if you are coming pursuant to parole, you do not have to worry about this new rule. Additionally, if you or someone in your party of people you're traveling with has used the CPB-1 app, then you are not having to deal with that requirement. So it doesn't necessarily mean that you yourself have to do it, but it has to be you or someone who you're traveling with who is also a family member. And that same rule applies to the asylum protection rule. So basically, if someone in your party applied for asylum in a third country that they pass through, for example, Mexico, then your entire party is able to avoid application of this rule. I will say this rule is very complicated in the way that it's drafted and the way that it's written. And that's something that immigration law suffers from very often. It is these messy kind of carve out rules. But what I think is important is for us immigration practitioners is to think about workarounds to this rule and think about how we're going to combat this presumptive ineligibility that's going to start occurring for many asylum applicants.
Right. And, sometimes some countries also have unrest or distress. So, I mean, stuff like that also affects asylum. What if there are people who had to flock into the US?
Right. And this rule does not take account for that, right? It's not saying, well, you are, coming from this country, so you don't have to apply for asylum in this third country. It's applying to everyone, unless, like I said, someone in your party has already done, complied with the rule, or you're coming
Mhm.
pursuant to a parole process. So, for example, for Ukraine, this does not create any sort of exceptions, but it's also important to note that this only applies to applicants presenting themselves without authorization to enter at the southern border. So, for example, for Ukraine, if they entered, through the airport, this wouldn't apply to them. So this applies to largely South and Central Americans who are seeking asylum in the United States.
Okay. Thank you for taking that up. Very interesting. And what are the timelines of asylum application adjudication? And I hear it really takes a lot of time, to get approved or denied, or even to get a call from the court. So is it so? And meanwhile, they get EAD, right? How long would it take to get EAD?
Right. So yes. So for it depends on what category, what kind of docket you have. If you're in immigration court, and if you're, like I said, defensive or affirmative, going to have very different waiting times. So for example, everyone, typically all applicants who entered the country more or less around August 2021, or further in the present, so up until now. So from August
Mhm.
2021 up until 2024, a lot of cases are being adjudicated very rapidly. So they have what's called the dedicated docket, or the rocket docket, as people call it. And so the rocket docket, originally the court put forth that they wanted all of these asylum applications done, concluded within 6 months. That was the original timeline for these applications, because the idea is that there's a really big backlog, and so the court wants to address the backlog by adjudicating them really quickly. However, I feel like, in my experience, they've been largely unsuccessful with this. I think even now it's been eased to somewhere around like 8, 10 months, because it's just impossible for the court to adjudicate those asylum applications in that short window of time. I will note that the dedicated docket applies to families who are recent entrants. So if you're a single person, you likely will not be put on the dedicated docket, as it is dedicated for family units that are applying for asylum who entered post 2021. So for these people, the cases are going to be accelerated. You'll probably get an adjudication within the year. So
Mhm.
that, that is a pretty fast moving process. However, fast moving processes aren't always good, with respect to it. It depends on the case, right? If it's a really strong case, you want your case heard immediately so that you can get that approval. If you have not so strong of a case, it's not great to have your case adjudicated right away, because now you have an order of removal and no immigration benefits. And with respect to the employment EAD question, like I said, you do need 6 months of an application pending to get that employment to apply to get that employment authorization document. Although the application, typically we're seeing new initial applications to accept employment for asylum seekers are only taking a few weeks.
Mhm.
Maybe if you're unlucky, a few months, but we're seeing them come back very, very quickly.
Mhm.
And so for this reason, the rocket docket is kind of in excuse me, in conflict with the asylum applicant's ability to get the employment authorization document, because the government is saying we want to adjudicate these earlier than 6 months, and people coming in are like,
Mhm.
I would like to have my application pending for maybe 8 months so I can get an employment authorization document that's valid for 5 years. That benefit is worth a lot to a lot of people. So it's kind of, the applicant doesn't have a choice. There's nothing that the applicant can do to kind of delay the process, because any applicant caused delays will actually cut away from the time of that pendency of your asylum application. So it's almost entirely in the hands of the court. There are some things attorneys can do regarding strategic motion work and making sure that there's nothing that the attorney's doing to cause any delays in that accrual of time, in order
Mhm.
to put your client in the best position to get that employment authorization document, which, like I said, is a huge benefit that many people want. And so, especially if you don't have a strong case, getting that employment document is even more important, because that's probably the only benefit you will ever receive if your application is ultimately going to be denied.
Okay, thank you for taking that up. And these days, a lot of people are crossing US from Mexico. So people from Asian countries travel to Mexico and then come to the US. And is it valid case to get asylum as they are entering through a third country?
Right. So in this case, if I was, for example, from India and I flew maybe to Guatemala, I'm not sure where exactly they might be flying, but let's say that I fly over there and then I pass through Mexico to the southern border. Yeah, that's going to be a problem for the new asylum rule, because they're passing through a third country. In this case, they're passing through two third countries between India or between, whichever country in Asia and the southern border. They're passing through Guatemala, maybe they're passing through Mexico. So the rule would be that one person in that person's family unit party of people that's entering needs to apply for asylum in Mexico or in Guatemala in this case. And it's specifically important to note that it's not just applying for it, you actually have to wait for your decision. So you have to apply and actually get a denial from that country before you can seek asylum based on this new rule. And so it's not enough to just apply and then continue on your way to the United States. You need to actually see the process through, because any abandonment by the applicant actually won't count towards satisfying the requirements for this rule.
Thank you for taking that up, Gianna. Thank you, really. It's been very interesting. I mean, I can only imagine how vast this topic is. We're
It really,
almost hitting an hour, but if you have more time, it'll be great, to stick through a little more. Yeah. So
yeah.
let's hit to some questions from the folks out there who are watching us right now. I think let's take up Rajesh Chauhan first. Are there any organizations or initiatives that support asylum seekers in their job search and integration into the workforce?
So that is a great question with regard to helping them, obtain jobs. I do not know of any offhand, but I do have a list that I brought with me of nonprofit organizations, which are really great at helping asylum seekers with their, legal cases. One such organization is Carecen, Carecen. Carecen is a nonprofit organization which works to help, asylum applicants who fall below a certain poverty threshold. They also do a lot of applications for temporary protected status from countries like Haiti, Venezuela, Honduras, and El Salvador when they were doing re-registrations recently. And they typically, from what I know, they're usually free or very, very low bono. So these types of organizations, also there's a lot of nonprofit organizations and NGOs that put out legal materials that are really great. But with respect specifically to job search and integration into the workforce, I don't know if there are many organizations that are, here to do that. I do know that there are a lot of refugee resettlement organizations that deal specifically with refugees outside of the United States and helping them resettle here with housing and work and such like that. But contrary to popular belief, there's actually not that many resources for asylum seekers. You hear in the news that asylum seekers are getting all these benefits and they're getting all these things. Meanwhile, other people have been waiting for years for their cases to be heard. But when you actually look at the average asylum seeker, they can't get health care. They can't, pay their taxes. They have to apply for an ITIN number. They have a hard time being employed. They have a hard time buying a house. And this is actually the reality for a lot of asylum seekers, is that it's extremely hard for them to establish a life here, contrary to popular belief.
Right. Thank you for making the
Yeah.
picture clearer, I think. Yeah. And this one is from an anonymous YouTuber. How do asylum seekers navigate the job market in a new country, especially if they are unfamiliar with the language or culture?
This is also a very interesting and related question. So, it depends. A lot of asylum seekers, for example, like you said, are unfamiliar with the language. So they're going to tend to kind of, reside in areas of people who are similarly situated. So, in Long Island, in the New York City area, we see pockets of, for example, Hispanic individuals who, the stores are Hispanic, the job, the employers, their kind of entire neighborhood. And this way they're kind of able to, assimilate in like sort of a slower rate, because they're able to have community with people who do speak their language. I think it is very hard. It depends on the kind of job you're trying to get into. Typically if you're trying to get into like a professional job, you will need to learn the language, of the applicable, usually English. But I think there's not one right answer to this question. I think in my experience, the best way that you can familiarize yourself with a new environment is just kind of immersion, right? So for me, interacting with Spanish-speaking people, going to Spanish-speaking restaurants, getting outside of my comfort zone in a way that really forces you to learn. And I think for asylum seekers, that's a reality that they can't avoid. Whether it's
Mhm.
going to the store, applying for jobs, or just hanging out in public settings, you're going to learn that new language, and you're going to learn more about the culture.
True, true. And it's important to know the culture where you're planning to at least settle, even if it's just for a week or a month or a year.
Right.
Yeah. Let's move on. This one is from Cobrin Rees. I haven't begun my asylum application. After crossing the border illegally, I ended up with a court at my sponsor's address. Now living in a different state in 2027, I wish to apply from here. And there is a follow up saying my I-589 form was rejected, requiring submission at the sponsor's court, which is far away. How can I initiate my asylum process from my current state?
Okay, this is a great question. I love to answer this. So the first, and what was this person's name you said, Nipa?
Cobrin Rees on YouTube.
Okay, Coburn Reese. So Coburn, the first thing that you're going to want to do, especially, it depends if you want to get an attorney or not to help you with this, but seeing as your address is the previous address that you had, now you're living somewhere else, you need to file what's called an EOIR Form 33, and this is a change of address form. It sounds to me like you are in immigration court because you stated that they want you to submit the application at the court rather than at USCIS. So it sounds to me, I'm assuming a little bit, but it sounds to me like you filed it with USCIS, and USCIS then rejected it and said, we don't have jurisdiction. The court actually has jurisdiction. And that's typical. Once you enter the border, like you said, illegally or without a visa, you'll get that notice to appear and actually be placed into immigration court. So the first thing you need to do is identify which immigration court actually has your case. You can do that by typing into Google automated case information, or ACI. And with that, you can put in your 9-digit A number. This A number will be found on the papers that you received at the border. It should be in the upper right corner. It'll have the letter A, and then it'll have 9 digits. What you can do is you can take this number, put it into the automated case information website, and it will tell you where your court is, when it is, whether it is virtual or in person, and other things such like that. Once you find out where it is, what you can do is file the necessary paperwork. So you're going to want to file a change of address Form 33, and you're going to want to, it sounds like, ultimately file your asylum application. When and how you do that is going to depend on when you entered, like we talked about that 1-year deadline. You want to make sure you get it in before then. With respect to how to file it, it depends on which court you're at and if you're doing it with an attorney or not. If you're going to do it with an attorney and you entered recently, more than likely your case will be online. So more than likely your attorney will be able to go on and upload all of that for you. If you're trying to do it yourself, it depends on the court. You might have to actually go in person to do it, which is, I know it's not great. But that's why if you hire an attorney, they can actually do that all for you. So you don't have to go there.
Great. So, Cobrin, I think it would be very wise for you to consult an attorney and hire one as well. All right. So, moving on, we have this one from Ram Kumar asking, recently, I have been hearing a lot that people are getting GC done through asylum cases within 1 or 2 years of time. Is it really true?
Um, so yeah, this is a great question. So for some people, yes. Like I mentioned, those people who are recent entrants, say I'm a
Mhm.
recent entrant, I'm from a country that's in really bad political turmoil. Let's say I'm from Venezuela and I was a political opposer, and because of that, I was persecuted. I have documentation, I have evidence, I'm a really good attorney. I entered in August 2023, and let's say I entered with my daughter. And so I'm on that rocket docket that they want to take care of within 6 to 8 months. So let's say it was taken care of within 6 months. So by December, a little bit of math, by December, February 2024, I have already gotten an approval on my asylum case. Next, there's another process. So now I'm an asylee. My case has been granted. If I don't already have a work permit based on my pending application, I can apply for an A5 work permit now that I have been granted asylee status. 1 year after the grant of your asylum application, you can apply for residency in the United States. And actually, based on a recent USCIS policy update, you can actually even apply before that. So it used to be the case you have to wait exactly 1 year before you apply. Now any time where that application for your green card is actually pending will count towards that 1 year requirement. So I typically recommend you wait maybe a month or 2 months before filing it, because just in case they process it so quickly that it is under 1 year, then you will not meet that 1 year continuous physical residence requirement following your asylum grant. And so for that reason, we recommend you file it a little bit after. So let's say we're 6 months for the asylum grant, 3 months in after that, we're 9 months in, we file the green card. The green card takes about a year and a few months. Yeah, it's entirely possible that that person got their green card within 1 to 2 years time, including the entire immigration court. And obviously there's the affirmative process as well. Let's say I file it affirmatively. USCIS has this discretion to decide that, schedule your asylum interview and decide that as quickly or as long as they really want. I will say though, for the people that aren't in this dedicated docket space, or for asylum applicants who are affirmative, there are many people who've been waiting almost a decade or longer for their asylum applications to be adjudicated, because the general backlog on these cases has been extremely long. So I've worked on numbers of cases they filed in 2013, 2014, 2015, and they still have not had their final hearing, or USCIS still has not adjudicated their case. They're actually doing now first in, last out. So they're trying to get rid of the cases that are coming in now, and slowly chipping away at that backlog. So I guess this is where people say like, oh, the people coming in now are having it better. It's just that they're having their cases processed faster. But faster is not always better, right? Because faster means maybe not a work permit, whereas people who've had their applications pending for 10 years have been working and living lawfully in the United States in a lawful pending asylum status for like 10 years. So it really depends on, what your intentions are and what you'd prefer, and the strength of your case as well.
True, true. Thank you so much for taking that up from Ram Kumar. Well, I think we are almost coming to an end because we've crossed an hour, and uh, there is Dan Nandan saying, very informative. Thank you, Gianna. Thank you so much.
Of
That's our
course.
president there of Higher IT Inc. Yes, thank you so much. And folks out there, whoever have dropped in your questions, so sorry we couldn't take them up on the show, but very happy to tell you that Gianna is with us, and Gianna and I, we are going to check out the questions, and we are going to respond to each one of you for sure. And I think, Gianna, we couldn't touch up on so much, on asylum, because there's so much really to talk about. So, I mean, if you don't mind, we would love to continue this topic in the coming week as well, if that's fine with you.
Yeah, we might have to start a series because I have a lot more.
For sure. I mean, you were saying 15 pages you prepared, so I can only imagine.
And I only got through, I think, 4. So
Four, right. So there's so much more to talk about, friends. And I'm sure you two have so much to ask Gianna, even. So feel free to contact us, contact Gianna, and keep dropping your questions in the comments. We will take them up for sure. And I'll just say hi to Ramsey, Ava Wilson, Imran, Yeswant. Thank you, everyone. Thank you. And we will get back to you. Tanya, Dexter, Yuri, Mayur. Yes, thank you so much. And thank you so much, Gianna, today for joining us in this um, discussion, this masterclass, from you. Thank you.
thank you so much for having me. I really enjoyed it.
Me too, me too. So, just like that, friends, we have come to the end of yet another fantastic webinar today on immigration and jobs talk show. But before we sign off, I really want to say thank you once again to our incredible guest, Gianna Marie Florentino, for sharing her invaluable expertise today, and this masterclass we had with her today on how to uh, get your asylum approved in the US. So, yes, friends, thank you so much. And Gianna, you are an absolute rock star today. Thank you. I'm really grateful today.
Thank you very much, and thank you to all of our viewers and all those great questions. Thank you so much.
Have a great day. Have a great month. Happy April, I would say. Bye bye,
You
Gianna.
too. Bye-bye.
Yeah. And friends, yes, thank you so much for all your time and your amazing comments out there, your questions. Thank you for tuning in and for the support you always give us. So remember, folks, the journey doesn't end here. Keep striving, keep learning, keep chasing your dreams, and of course, stay inspired. And if you have any questions, you want to contact me directly, here's my number on the screen. 408-335-6444, or you can just email me at nipa@higheritpeople.com. Thank you, friends, and happy to tell you that I'll be joining maybe in just another 15 minutes or so. We have another webinar coming in, and that is going to be with none other than Uma Mantravadi. And I just say stay with us. Don't go anywhere. Thank you so much for tuning in today. It's Nipasa Pradhan signing off for now, but be right back very soon on Immigration and Jobs Talk Show.
Are you an IT consultant seeking a new opportunity? We offer job placement services for U.S citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H-1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.